less in our ward. They got severely curtailed. And the other thing is asset forfeiture. People want to say we're taking money and without due process. That's not true. You know, we take money from dope dealers.
So you're saying, okay, so you're saying the asset taking you used to do and it had an impact, right? And you're not allowed to do it now?
No, they have curtailed it a little bit. And I'm sure the folks are...
And that's for legal reasons or just political reasons?
They make it political and they make it, they make up stories.
I'd like to look into that, okay? There's no reason for that. Danny, do you think there's any reason for that? Are you aware of this?
I'm aware of that, Mr. President, and we have got a great deal of criticism for the asset forfeiture, which, as the sheriff said, frequently was taking narcotics proceeds and other proceeds of crime, but there has been a lot of pressure on the department to curtail some of that.
So what do? So in other words, they have a huge stash of drugs. So in the old days, you take it. Now we criticize if we take it. So who gets it? What happens?
Well,
keep it?
we have what is called equitable sharing, where we usually share it with the local police departments for whatever portion that they worked on the case. And it was a very successful program, very popular with the law enforcement community.
And now what happens?
Well, now we've just been given there's a lot of pressure not to forfeit in some cases.
Who would want that pressure, you know, I mean, other than like bad people, right? But who would want that pressure? You would think they'd want this stuff taken away.
You have to be careful how you speak, I guess, but a lot of pressure is coming out of Congress, was coming out of Congress. I don't know if that'll continue now or not.
I think less so. I think Congress is going to get beat up really badly by the voters because they've let this happen. And I think you'll be back in shape. So asset forfeiture, we're going to go back on, okay? I mean, how simple can anything be? You all agree with that, I assume, right?
Absolutely.
Do you even understand the other side of it?
No.
It's like some things, sort of like the Iran deal. Nobody even understands how a thing like that could have happened. It does nothing.
You're allowed to profit from the illegal proceeds, right? Okay. So if you're going to sell narcotics and sell illegal drugs in our country, you also cannot profit from it. So we seize those profits.
Due process. So do we need any legislation or any executive orders for that, would you say, David, to put that back in business?
I don't think we need any executive orders. We just need kind of some encouragement to move in that direction.
Good. You're encouraged. I love that answer, Chris. That's better than signing executive orders and then these people take it and they make it look so terrible. Oh, it's so terrible. I love it. You're encouraged, okay? Good. Asset forfeiture. You're encouraged. Okay. Yes, sir.
Clarence Thomas questions legality of letting cops take innocent people's stuff. The Supreme Court Justice's skepticism of civil asset forfeiture may signal the court would be receptive to a review. Washington. Supreme Court Justice Clarence Thomas sent a strong signal on Monday about his feelings towards civil asset forfeiture, a controversial law enforcement tool that allows police to seize cash and property from people who haven't been convicted of a crime, and in many cases, haven't even been charged. In a one-line order, the High Court declined to hear a case related to the practice. But in an accompanying statement, Thomas broadly questioned whether civil forfeiture could withstand legal scrutiny. This system, where police can seize property with limited judicial oversight and retain it for their own use, has led to egregious and well-chronicled abuses, wrote Thomas. I am skeptical that this historical practice is capable of sustaining, as a constitutional matter, the contours of modern practice. Thomas went on to outline his concerns, noting that legal precedent, most recently in the Supreme Court's 1996 Bennis v. Michigan decision, has been based largely on early statutes involving property related primarily to piracy and customs. The evolution of civil forfeiture as a weapon in the drug war has led to dramatic surge in its use over the past 30 years, with law enforcement authorities reaping billions of dollars in cash and goods for their coffers. Although the practice once focused on the seizure of pirate ships and cargo, police now routinely use it to sweep up cash, cars, jewelry and even real estate from people based solely upon the suspicion of criminal activity. Because this process takes place in civil proceedings, not criminal, property owners aren't granted rights to due process or to an attorney. And unlike in criminal cases, where defendants must be found guilty beyond a reasonable doubt, police in civil forfeiture cases are often only required to establish weak evidence showing seized property is connected to a crime. Thomas' criticism of civil forfeiture comes as efforts to reform the practice have gained momentum at both the state and federal levels, bolstered in part by reports of systemic abuse. In his statement, Thomas cited a 2015 study by the Institute for Justice, a libertarian public interest law firm, which outlines the enormous financial incentives for police to seize property. Critics of civil asset forfeiture, including the Institute for Justice, say weak state laws and poor oversight have given rise to a system of policing for profit, which leads law enforcement to prioritize activities that bring in money over those advancing public safety. As Thomas explained, abuses do not affect all people equally. These forfeiture operations frequently target the poor and other groups least able to defend their interests in forfeiture proceedings, Thomas wrote. Perversely, these same groups are often the most burdened by forfeiture. They are more likely to use cash than alternative forms of payment, like credit cards, which may be less susceptible to forfeiture. And they are more likely to suffer in their daily lives while they litigate for the return of a critical item of property, such as a car or home. Thomas' comments may suggest that the court would be receptive to a future legal challenge. This is a significant opinion by one of the justices of the Supreme Court questioning the constitutional validity of civil forfeiture, Darpanisheth, senior attorney with the Institute for Justice, told the Huffington Post. He's strongly signaling his skepticism and his belief that civil forfeiture is unconstitutional, and he pretty much outlines the blueprint for why the earlier court decisions can't be squared. Sheth noted that Thomas appears more skeptical than he did in 1996, when he sided with the majority in ruling that innocent owners do not have a right to due process in civil forfeiture cases. I think we can definitely count Justice Thomas in a solid vote questioning the constitutionality of civil forfeiture, Sheth said. Now, it's a matter of finding a case that the Supreme Court will take. The Institute for Justice is involved in a lawsuit challenging an alleged machine-like forfeiture scheme in Philadelphia, where authorities took in more than $64 million from 2002 to 2012. The Philadelphia District Attorney's Office used $25 million of that money to pay salaries of the prosecutors who brought the forfeiture actions. Right now, that's down in the district court, and hopefully it will make its way up, said Sheth. But litigation is slow,